Well, good morning, and thank you again for joining us today. We know your time is valuable, and we're going to do our best to start this on time and bring this information to you in a relevant and timely manner. For those of you who are not familiar with INA, we are in our 25th year of working with independent insurance agents around the country, helping you find the right insurance products and solutions for your clients. We began our business in 1987 with a primary focus in health insurance products. So as you can imagine, we have a lot of vested interest in this new regulation, just like you do. Over time, like many of you, we've diversified our lines of business, and now we not only operate one of the most successful independent health insurance and ancillary benefits managing general agencies in the country, we also have a very strong footprint in individual life insurance, long-term care, and fixed annuities. In other words, we are well positioned to help you continue to grow your practice today and in the future. I hope you're already working with us, and as I look through the list of attendees, I see many of our good friends and longtime clients on the line. Those of you who are not currently working with our office, I hope you'll give us a chance to show you what we do. But as promised, let's begin. Well, here we are. It's been over 2 years since this bill was signed into law, and a month following the landmark Supreme Court ruling. And we better get used to the idea that this massive health care bill is going to continue to be implemented, even as we continue to learn what's in it. At this point, I believe the responsible thing for all of us to do is to work better to understand what is coming and to prepare our mutual clients for the impact to them, to understand what their impact will be in their own personal situations. Simultaneous to that, I hope we all continue to lobby our representatives for meaningful changes to this law, which will hopefully in turn bring us reform that might actually help make health care more affordable, and we all know we desperately need that. Meanwhile, if you don't already have this visual of all of the new agencies that were created under PPACA, the ones that have been expanded, or the ones that have been given massive new authority, call into our office at the end of this webinar and we'll send you one of these. Meanwhile, I promise to walk you through what's next of PPACA, so let's get to it. So first, let me remind you of some things that have already taken place. As you all know, non-grandfathered plans have already had all of these provisions take place. I don't have to list them for you. By now, they're all old news. One thing I would remind you of is this very last bullet. The new non-discrimination requirements for fully insured plans were implemented and then pulled back, and we now sit waiting for those new rules to come out from the IRS. I'm not quite sure when to expect them or even if to expect them, but I do think we have to keep our eye out on it because those of you who attended previous webinars realize the impact of those new non-discrimination rules to employers in the fully insured market. So I'll keep watching, our staff will keep watching, and we'll keep you informed if anything new comes out. 2011, new regulations included the following: the unreasonable premium increases oversight. Now, I will tell you that despite a lot of pushback on the fact that the federal government determined that 10% was an unreasonable premium increase, that number stands. So for the foreseeable future, the decision has been made that it will remain at 10%. Now, the rest of these, again, you're already aware of them. The one thing I want to take a couple of minutes to talk about this morning are minimum loss ratio requirements. As you know, there are new rules that state that carriers must spend between 80 and 85 cents on the premium dollar on claims or a very narrow window of things, or refund money back to the participants if they don't. Now, these rebates are going to be hitting mailboxes soon, so I do want to walk you through a couple of things that you need to know as a result. So first, understand that the rebates have to be calculated by state and then by line of business. So each carrier will go through their book of business and they'll evaluate their loss ratios in small group, and then in large group, and then in individual. If the carrier did not spend 80 to 85 cents, and again depending on the size, of each premium dollar towards actual claims and or initiatives to improve healthcare quality, it must refund the difference to all policyholders in that state for that line of business. Even if a particular group ran really, really poorly, if the overall evaluation of that geographic region for that line of business did not meet the federal requirement, that group will still receive a refund. Now for 2011, the refunds must be issued to the employer, or in the case of the individual market, to the individual policyholder by August 1st, 2012. Now on the group side, letters had to be sent not only to the employers, but also to all employees who were participants in that employer's plan in 2011. One of the things that's just really challenging, I think, for employers is the fact that those letters are even going out to terminated employees, even though the rules are in place that allow an employer to exclude those terminated employees from receiving the benefit of the rebate. In other words, the employers have two options, and they have several, and we'll walk through a little bit of that in a minute. But the options are that they are either going to use the rebate for those individuals who are participants in the plan in both 2011 and 2012, or in fact, they can use those monies to only benefit those employees currently insured on the plan in the year 2012. Now, I fully expect, and so do most people that I associate with and know, that these rebates are going to create a lot of confusion on the part of the employer. If you've got employers that are already receiving these checks, I'm sure you're already getting many questions. Well, I think that this is another area that we could take a substantial amount of time to go into in detail, and frankly, we just don't have time to today. So what I'm going to tell you are a couple of things. One, the rebated amount can be handled by the employer in one of four ways, and each of those carries different tax and reporting consequences. And I've seen a couple of pretty good white papers and articles written on how all of this works. The IRS has also issued a 7-page bulletin which has specific examples and a series of frequently asked questions that they put forth just a couple of months ago. Now, we have this document available, and if you'd like one, at the conclusion of this webinar, one of our employee benefits specialists would be happy to get that for you. Call in and ask for this. It's the MLR FAQ from the IRS. Now, how's that for a bunch of acronyms? But call and ask us for that. My advice to you would be that you get that document over to your clients for their review when they ask questions. That will help you provide them the service without putting you in the spot of trying to answer some pretty difficult questions that may come up. Other issues that came about in 2012 included the W-2 reporting requirements for employee benefits. Now, this has changed quite a bit, and it only currently will apply to those employers who issue 250 or more W-2s. There has been some confusion on this. Some reports have been that the only people that have to comply are those with 250 or more employees. That isn't exactly the way the rule works. If you have an employer with a lot of turnover, with a lot of seasonal employees, with a lot of part-time employees, they may find themselves issuers of more than 250 W-2s in a calendar year. And if they are in that boat, they are required to report the value of the employee benefits on the W-2. Now, this is for informational purposes only. It isn't intended to be taxable to the employee, but it does have to be reported. Another really big thing that's coming out right now and that carriers are spending a lot of time on are these new Summary of Benefits and Coverage, SBCs. Now, quite honestly, this is another topic that I could spend an entire webinar on. Just rest assured of this. If you placed a policy with our office We're currently working very closely with our carriers and our third-party administrator vendors to make sure that all of the employer groups that you have with us will be in full compliance on the first plan year on or after September 23rd of this year. Keep in mind that there's a very specific format that has to be followed, and there have to be examples of specific services that an insured might receive, like what would happen if I were a diabetic and I had a certain amount of claims? How would my plan work? One thing I think people are missing is the fact that HRAs, HSAs, and FSAs are also considered to be health plans. Therefore, either those benefits have to be included in the SBC for the overall health plan, or separate SBCs have to be issued. So if you've got employer groups out there with these types of programs, they need to be aware of the rules. And again, very specific formats have to be followed, and this is another thing that we do have an FAQ that came out of the Department of Labor detailing some of the things that you need to understand as it relates to the summary of benefits and coverage. The one thing that I would say is that if you do have employer groups out there who are with fully insured plans, I believe that for the most part, for the basic benefits, they're in good shape. Those carriers are going to be issuing the SBCs. If you have groups that are self-insured, not through our office, I recommend you talk to them and discuss with their TPA to determine who will be responsible for these forms. Other things that you should be aware of are that these SBCs are really part of the whole exchange process. The idea is that if we come up with 4 very, very basic pages of information that are very, very easy to understand, that an employee or an individual client in the marketplace won't need you anymore, because they'll be able to look at these 4 pages, and then the exchanges will have this information on them, and the writers of the bill believe that this will be an easy way, and it'll make health insurance kind of like the Expedia of buying a flight or a hotel, right? So that's the design behind these, but as with all things we've seen, something that was intended to be very easy becomes very overcomplicated. And there are additional rules and tentacles that are coming out of this particular regulation, including, for example, that when an employer brings on a new hire, they have to provide them with these SBCs of all the plans available to that employee, and have to be able to walk them through the plan choice. So just be aware that these SBCs, this is another topic you're going to want to talk to your employee benefit specialist at IMA about. This is another topic you're going to want to be talking to your carriers and third-party administrators about. And this is another thing that you're going to want to get that FAQ from us on, because it will, again, give you some basic information about how these will work. I will tell you this, I was talking to my husband about this as I was studying and going on a trip this weekend, and I was reading frantically just to update myself on all the rapid changes coming out of Washington, D.C. on all of these topics, and he made the comment to me that it sounds like, tax attorneys just got a lot of job security, and I would have to agree with that. This becomes more and more complicated every day, and between the MLR rebates, the summary of benefits coverage, I think that the job security for employment and tax attorneys definitely got stronger. And I'll tell you this as well, if 2012 is going to be a boom year for tax attorneys, 2013 is going to be the year of IT. That's because in just a few months, state exchanges are going to have to meet the progress testing requirements for their state exchange. Also, insurers are going to have to comply with rules to determine electronic eligibility of applicants on the exchanges. Employers in 2013 are going to have to begin to notify employees of the availability of the exchanges and their possible eligibility for subsidies. And on a very quiet note, January 1st is the date that the new cap for flexible spending accounts of $2,500 is imposed. So it's kind of funny as you look at all of the changes we've just discussed that they are all quiet years compared to what we can expect January 2014. So let's get to this. So employer mandates kick in. Now, in order for an employer to know if he's subject to the requirement, an employer must first determine the number of full-time equivalent employees that he has. It's easy if he only has full-time employees. A full-time employee is anyone who works 30 hours a week on a regular basis during a calendar full year. But a full-time equivalent employee is one who works 120 hours or more per month. So the way that might work is that if you have 4 part-time employees who are each working 7.5 hours a week, in other words, 30 hours a month, they equal 1 full-time equivalent. What the law is really intended to do is to have an employer do the math on the paid hours in a given month for a given year, divide that by 120 to determine the average full-time equivalents that they have during the course of the year. If an employer has 50 full-time and or 50 or more full-time equivalent employees, that employer is required to provide affordable health insurance that meets certain minimum benefit requirements to all full-time employees or risk paying a penalty. Now, I emphasized a few things on this slide because I think we need to make some points because there seems to be some confusion out there. First, the employer will be required to contribute enough to the premium to make it affordable. Second, he'll have to offer comprehensive major coverage with no more than a 90-day waiting period for all full-time employees in order to risk any of the penalty. Now, the plan may be fully insured or self-funded. The funding mechanism is not what will be scrutinized. What the government will be looking at are the plan benefits and the employee's share of the premium to determine if the employer meets the minimum requirement. Let's walk through a couple of different scenarios. So if an employer offers no health insurance for their full-time employees, and if they do have 50 or more FTEs, as we've just discussed, then that employer would pay a penalty equal to $2,000 per full-time employee minus the first 30 employees. So the example that I have up here, let's say an employer has 40 full-time employees plus 20 full-time equivalent employees. In other words, let's just say it's 40 part-time employees, each working 15 hours a week. That employer is going to be considered to have 60 full-time equivalents under the law. In other words, he is subject to the mandate even though he only has 40 full-time employees. The way the penalty would work, if he offers no coverage to those 40 employees, you take 40 minus the first 30 equals 10 employees that he has to pay the penalty on. Penalty of $2,000 per employee would equate into an annual penalty to this employer of $20,000. I'm going to leave that slide up there for just a second and let you look at it. I'm also going to remind you that if we have time to answer questions at the end of this session, we will. So on the right-hand side of your screen in the GoToWebinar settings, there's an option for you to type in a question. If you type in that question, I'm not going to answer them during the session. I'll come back to them. And if we get to the end of this and our hour is up and we don't have time to answer them, I will be creating a response to all of those in a Word document, and we'll send it out to everybody who attended. So if you have a question, type it in, and I'll get to it either at the end of this session, answer those that I can, but in any event, we will answer them to the best of our ability and shoot you out a written response following the session. So let's go on to what happens if an employer does offer health insurance. So remember again, it must be an affordable plan that meets the federal requirements. If it doesn't, then they have to pay a penalty if any of their eligible employees, in other words, any of their full-time employees, qualifies for a tax subsidy. So keep in mind that to qualify for a tax subsidy, that employee, and we're going to get into the subsidies in a minute, but that employee must prove that their employer does not have an affordable health plan that meets the minimum requirements. If the employer does have a plan like that, that employee would not be eligible for a subsidy. So if an employer has a health plan that doesn't meet the requirements, therefore the employee qualifies for a tax subsidy, the penalty is the lesser of $3,000 per subsidized employee, or the previous rule, $2,000 per full-time employee minus the first 30 employees, whichever is less. So again, it becomes relatively complicated. It could also have unintended consequences. I've run some scenarios where an employer with a lot of low-income individuals, where the employer's contribution is not great enough to satisfy the requirement, could end up paying a penalty equal to that of his competitors, even though he offers a health plan and the competitor offers none. Now think about that for a minute. I don't think that's what the intended consequences were, but that is the way it works. Now, one of the challenges that we all have is that we still don't have the guidelines on exactly what the minimum essential benefits must be or what the standard plans must include. What we do know at this time is how to determine whether or not the plan is affordable. Now, there have been some changes on this from when the law was first passed and some clarification. So this is how it currently works. In order for it to be considered affordable, the required contribution for the self-only coverage cannot exceed 9.5% of that taxpayer's household income for the taxable year. Now, so if the employer's tax or the employee's, the taxpayer's income, whole household all in, is say $30,000, then 9.5% of $30,000 is the maximum the employer can have that employee contribute to the self-only coverage. I hope that's not too confusing. And again, this is another piece that we have available for you if you'd like this information in writing. But that's the employer penalty, that's the pay or play. And again, there's been a lot of confusion out there. I've heard even some people out there talking about how there's an employer mandate even for self-employed people. That is not true, other than the individual mandate. The employer mandate is strictly for those with 50 FTEs or more. So let's talk a little bit about the individual mandates then. So the individual mandate starting in 2014, as upheld by the Supreme Court, if someone does not buy at least the minimum essential benefit plan, then they're subject to a penalty. The penalty in 2014 is the higher of $95 per individual or 1% of the family's taxable income. Family of two in this example, if their taxable income is $26,000, 1% of that is $260. That would be greater than $95 times 2. In a large family, the penalty tax is only assessed for up to a maximum of 3 individuals in the household. In 2016, that goes up to the higher of $695 for the first 3 individuals, or 2.5% of the taxable income. Now, there's a lot of debate as to whether or not the penalties will be high enough to provide the intended incentive. And the debate continues to go on. These individual mandates, of course, were designed to get more of the young and healthy into the pool, particularly because starting in 2014, no pre-existing conditions can be imposed, carriers can't deny coverage, and so the worry has always been that if only the sick buy insurance, the cost of insurance will go up, and that's been the concern all along. So I don't know, and we can debate ad nauseum whether or not these penalties will be high enough to actually incent people to go into the insurance coverage, but keep in mind that on top of this mandate, there is also the tax subsidy, these tax credits that we're going to talk about in just a minute or two. I want to just cover, before we do, a couple of additional things. In 2014, the small business tax credits increased to 50%. These are for employees or employers who have fewer than 25 employees with an average wage of under $50,000. Now remember, we have the small business tax credit now, and it's lower, but it is there. So if you have small businesses with relatively low wages, this may be something you could already be talking about. Here's the thing to keep in mind. In 2014, when this credit moves to 50%, the only way an employer will qualify for the credit will be if he purchased his group policy through the exchange. If there's something that you should be talking to your local representatives about, it's that rule. There is no reason that an employer, because of the way the tax credits are filed for, needs to buy that policy through the exchange. I would strongly recommend that be one of your talking points to your local representatives, and I hope you're talking to them, is we want to get this tax credit outside of the exchange. But in any event, another thing that happens in 2014 is this massive expansion of Medicaid. Now, in some states, they already have these provisions available, but in others, they don't. In other words, in some states, Medicaid only covers children or parents of children or disabled individuals. The way the new Medicaid expansion will work is that it will be all eligible citizens in that state who have up to 133% of the federal poverty level, and this Medicaid expansion will be 100% federally supported only for the first 3 years, and then it'll start to taper back. This is why you have so many states arguing this point. The states at first were forced and told that in order to get any Medicaid dollars from the federal government, they had to buy into these expansions. Now, one of the things the Supreme Court said was that if a state chooses not to go along with this expansion, the federal government can't take their other Medicaid money away from them. So that was one thing that took some heat off of the states. But the reason the states are worried is that if they do extend Medicaid to all eligible adults in their states and all eligible citizens up to 133% of the federal poverty level, they're worried about what happens in 4 years when the states have to start coughing up some of the money for that expansion. Now, I want you to understand that as the states make those decisions, it's going to impact the number of uninsured that PPACA was supposed to take care of, because one of the ways the PPACA was going to really reduce the number of uninsured in our country was through this Medicaid expansion. Now, I want you to understand that if the states don't expand Medicaid, those individuals will not be left out because they will also still qualify for a tax credit. So let's take a look at the tax credit. These subsidies are tax credits and available on an advanced basis, even if an individual has no tax obligation. It's going to work very similarly to advanced earned income credit. So based on the current legislation, an individual will be subject to or eligible for a subsidy if their family income is at or below 400% of the federal poverty level. These are the 2012 numbers. They are indexed, so they go up every year. But as you can see, the 400% of federal poverty level currently in 2012 for a family of 4 is $92,200. Think about that for a minute. Think about $92,200. I know in the state of Idaho, where we're based, the estimates are that that covers about 92% of our state's population will now be eligible for a tax credit if their employer doesn't provide an affordable health plan that has a benefit package that meets the federal minimum requirements. So let me walk you through this a little bit, because there are several calculations that go into determining the subsidy, and it varies by income level. But for an example, let's look at somebody who is earning right at 100% of the federal poverty level. And let's assume that that family of 4 earning $23,050 has a premium for their family of $12,000. We're going to make it easy. It's $1,000 a month, $12,000. That family would be eligible for a credit of $11,559, leaving their share of the annual premium at $441. $441 would be their premium. The rest will be covered by taxpayers beginning in 2014. And maybe that's okay for somebody earning $23,000 family of 4. Maybe most Americans think that's okay. I don't know. So let's look at this. Let's look at what happens if you're earning $92,000 and you have a family of 4. The credit on a $12,000 policy would still be in the neighborhood of about $300 a month. Now, I don't know about you, but I think most individuals in this country would find a $300 a month tax credit to be enticing. But one thing you need to understand, and this is one of the reasons that we are in so much jeopardy, is that the only way they can get this tax credit is if they buy their policy through the exchange. Remember, I already told you the only way a small business can get their tax credit is through the exchange. I'm sure you see the pattern. Understand this. Right now, even though navigators are part of the exchange rule, and even though National Association of Health Underwriters successfully advocated to have insurance agents added to the list of people who can become navigators, as of today, there remains no mechanism for you to be paid as a navigator. So you can navigate, but right now you would be a volunteer in the system. So if the only place a person can qualify for a tax credit is through the exchange, and if the exchange remains as is and there is no mechanism to pay you, where does the scenario leave you? And how many of your existing clients will either qualify or turn to this entitlement? Another question that is being rapidly talked about is how is our country going to afford another entitlement? And that's a debate separate from this, but may have impact on this, because I believe it's something that's going to be taken up after the election this year. And if the subsidies go away or get dramatically reduced, everything else starts to go away along with it, because all of these things, the exchanges, the SBCs, the subsidies, all of these are really a house of cards that rely on each other. So something to keep an eye on and something to watch for. So I want to circle back and talk a little bit more about these exchanges. So the exchanges have to be up and running and ready to roll January 2014, right? Well, interestingly, in the law, there is an open enrollment period for exchange plans that starts in October of 2013. I'm still trying to figure out how plans that have to be fully operational on January 1st of 2014 will be ready to have an open enrollment in October of 2013. But one thing to understand is that these exchanges are going to be massively complicated. Within those plans, they have to be able to modify and stay current with all of the plan benefits. Also, they're going to have to be ready to do things like figure out how somebody qualifies for eligibility under Medicaid. So in other words, when somebody goes in and they apply for something on the exchange and they look at the SPCs and they decide which plan they want, they're going to enter their family information, and all of that information has to go out to the appropriate state agencies to determine whether or not that person is eligible for Medicaid or SCHIP or a PPACA subsidy. If they are eligible for a PPACA subsidy, the plan then, or the exchange then has to be able to communicate with the plan to make sure the carrier knows that the federal government is going to be sending a check for those premiums. And the employer has to be notified so they know what to do with the tax withholding. So the complexity behind all of this is what leads most people that are really actively involved in this to believe that there is a very, very high probability that even if PPACA survives the November election, that there will still be a pushback probably to 2015 before most of the 2014 requirements actually kick in. Quite frankly, because most people believe the exchanges will not be ready And if the exchanges aren't ready, the subsidies can't happen. And if the subsidies can't happen, the individual mandate can't happen, and so on and so forth. So it's simply a prediction. We're really not sure, but that's what people are assuming right now. So again, here are the things to know about the exchanges. They will be the processing centers for Medicaid, S-CHIP, and PPACA subsidies, the conduit for the premiums to be paid. And the two things, again, you have to remember are that to receive a PPACA subsidy or a small business tax credit, those people must purchase their policies on the exchange. So what's the impact to you? Again, there is no established mechanism to compensate you for your role as a navigator inside the exchange. And it could happen. I hope it happens. But if it doesn't, you have to ask yourself if it is possible that even your group clients will turn to the exchange. And if so, how will you prepare? And we're going to talk more about that in a minute. But I do want to circle back to the implementation timeline and talk about the fully insured plan changes. January 1, 2014, unless it gets pushed back a year, all fully insured plans will have to provide guaranteed issue to all applicants with no pre-existing condition exclusions. There will be massive price compression. There's community rating in a lot of states already. This is still going to have some impact on those states. It's going to have major impact in the states that are not community rated, because what you're going to see is the young and the healthy's rates are going to go up, and the older individuals on the plan's rates are going to go down. There will also be a new federal tax on fully insured plans, the HIT tax, if you will, which again is a relatively complex formula by which the federal government is planning to help fund for some of these subsidies. The tax will be applied only to fully insured plans and is guaranteed to make fully insured plan premium go up. No other way around it. So one thing that we continue to debate, most experts agree, PPACA is certainly not going to lead to cheaper fully insured health insurance. It's not going to lead to more carriers entering the market with brand new fully insured plans, because as everything becomes more complicated, things become more complicated for the carriers too. So where does this leave all of us? I mean, where are we? We're all in the health insurance market. You're in the health insurance market. I mean, what do we do? Well, I wish I had all the answers for you, but the truth is no one does. There are so many different predictions, and most of them counter each other. So what do you do? Which of you on this call are most at risk? Well, first, I would say that if you're solely writing individual health insurance for the under 65 market, you may need to rethink that strategy immediately. If you're receiving most of your monthly revenue from very small, fully insured groups, I think you need to diversify. But remember that no matter what, with every challenge comes opportunities for those that embrace them. And as frightening as all of this seems, this is no different. There's no question you're going to have to be consultative in your approach, and in doing so, you're going to have to make sure you uncover all the needs of the individuals and group clients that you serve. Mid-sized carriers are going to bring additional opportunities to you. Those carriers are diversifying their products, and they need agents to market them. The good news is that you already have the relationships. All you need to do is leverage them and make sure no one else is in your house. You can no longer afford to leave any money on the table, and why should you? You don't even need to be the expert in the new markets you expand into. You just need a good partner. And clearly, our organization would love to be that partner, and we have the expertise to show you how to write products that you may have been walking away from. Another thing to keep in mind is that employers are desperate for PPACA assistance, and no one is better equipped than you to help them. You're on this call for a reason. You have vested interest in your clients, and you care. You're learning more than most of your competitors are, and I guarantee you, you know far more than the employers do, because other than all of the new FAQs out on the Department of Labor website, which most employers don't even know to go to look for, who's telling the employers what's next? You are. So continue to do that, And when you need help, turn to an organization like ours, because even if we don't know the answer, we can steer you to the way to find it. Now, I do want to take 3 minutes, and I'm only going to take 3 minutes to talk about this particular emerging market. Many of you are already selling these plans, but I want to explain to you why you're going to see more and more of this in the coming months. You know, regardless of whether you've been selling these plans, you've always known that self-funding a health plan gives the employer enhanced flexibility in plan design. This is going to become even more important with all of the massive new mandates coming your way. Remember that in the exchange, deductibles are going to be limited. I think I told you, and if I didn't, deductibles in the exchange for a healthy or for an adult over age 30, no higher than $2,000. No higher than $2,000. So everything is going to become mandated, and as everything becomes mandated in the fully insured and exchange world, you're going to have employers that are going to need more flexibility. Self-funded plans also offer transparent renewals, data to drive informed decisions, wellness plans, and from your sake, you're able to go out to an employer and offer them a long-term perspective, a true strategic approach to managing costs, because I'm telling you, PPACA isn't going to do it, but you can, and you can continue to help your group. Now, what you may not be aware of is the differences under PPACA for self-funded groups, and here are just 4 of them. Loss ratio requirements, which, as you know, are creating an incredible amount of havoc, particularly for mid-sized carriers who have a higher expense ratio than those of the larger carriers. Community rating on fully insured will absolutely drive the cost up for younger and healthier groups, which happen to be the best candidates for alternate or self-funding. The ability to set agent commissions means that you're going to get paid what you're worth on a case. And you're able to help employers participate in claims up to a protected limit spectrum of exposure. In other words, you can provide these plans and do all of these things. Sorry, I thought my little thing was moving. Without having to have them go into the fully insured market. So really quick, I want to discuss the differences between a fully insured plan and a fully self-insured plan, because the plans I'm talking about you recommend to your mid-sized group fall in the middle, the alternate funded. And again, fully insured, a pooled option. Your groups pay a premium that is in part based on the claims experience in that state, and in the end of the year, if they've had no claim, the carrier keeps the excess premium to help offset the loss of the other non-profitable groups. And we've talked a little bit about how that works, but you understand, fully insured we all get. Self-insured, on the other hand, is where an employer takes all of the risk. And somewhere in the middle, we have these alternate funded plans, plans that are specifically designed with smaller groups in mind. In the last year, we've had 5 of our fully insured carriers come out with alternate funding for small employers. These are plans that meet the ERISA definitions of self-funding with additional protections built in to protect the smaller employer. Protections like solid reinsurance, monthly billing that looks like fully insured, but with the ability to get some money back if the plan performs well. Detailed reporting that allows the employer and his or her agent to actually manage the plan. And to the employees, it looks like the same plan they've always had. So again, when you ask yourself why the carriers have come out with this, well, it's because they're as worried as you are about the affordability of the fully insured market in 2014. And they know that their existing agents and their existing customers are going to need alternatives. So how do you know if somebody is a good candidate for one of these plans? Well, here are some things to watch for. I'd also use the analogy here of an investor. There's 3 kinds of investors. The ones who would rather keep 100% of their money safe, even under a mattress, and are willing to give up any opportunity for growing their money. Similarly, some employers will be willing to pay a higher premium every single year for health insurance because it's predictable. Those employers probably fall into the same category as those investors. Another investor is willing to gamble it all, put it all in single stocks and rides the roller coaster knowing that the risk equals the chance for reward. That kind of investor, probably a good shot for a fully self-funded plan. But the third kind of investor wants safety of principal, but also a chance at growth. This is the kind of investor that might turn to something like an indexed annuity, a long-term strategy for his nest egg where he knows that the money he puts into it he's never going to lose as long as he follows the rules of the contract, but he does have a chance for something back. This is the kind of investor, this is the mindset of somebody who's a great candidate for an alternate funded plan, where worst case scenario, the employer might be a little worse off than if he'd stuck with fully insured, but that risk is in exchange for the fact that there's a better possibility that should his plan perform well, he'll reap the reward of a refund. Other opportunities for you to diversify your revenue and bring more value to your client include HR support, telling them the things they need to know about PPACA, providing more COBRA support, EAP plans, life insurance to solve the business planning needs of the employer, worksite marketing to provide voluntary benefits to the employees. You know, some of those employers may very well have their employees turn to the exchange for their benefits, but they may still want to provide benefits back to their employees that tie them to that employer. Voluntary benefits are going to work great for that. Voluntary benefits right now are a huge market, and if you're not in them, you should be. Other markets, individual life, long-term care, disability, and annuities, think about the fact that for every 10 life group you have 10 prospects for all of these products if you'll just learn more about them and get in front of those clients. And remember, if you're new to any of this, we have the resources and the specialists in our office to help you. One thing I want to say is that we want to see you continue to be informed. And in 2012, we are holding our second Top Producer event. This is an invitation-only event that is being held September 10th through 12th. Because our commitment to you, our producers, extends far beyond webinars like this. In September, together with 20 of our top carrier partners, we are bringing together an event that you will not want to miss. Now, if you're not already registered, please contact our office as soon as this call ends. We have to cut off registration at 100 top producers, and we are filling those spots quickly. At this event, you're going to have an opportunity to talk firsthand to other top producers in your shoes and learn how they're overcoming the similar challenges you face. We're going to have sessions on PPACA to bring you even more up-to-date information in much greater detail than I can do in a webinar. You're going to have an opportunity to interact with top carrier representatives and hear what they have to say about successful strategies to write more business with them. Of course, you can hang out with your INA team and experience what it really feels like to be part of our family, and that is just at the networking and vendor events. We have put together some of the best keynote speakers in the industry to deliver specific ideas and strategies to help you earn more in the coming years, all while having fun and working less. Our team can show you our conference website where you'll see our lineup of keynote speakers and a sampling of the breakout sessions we have in store for you. As a side note, you'll see that this event will be held over September 11th. And we couldn't have an event on that date and bring you anything less than a motivational, inspirational message from someone who was not only at Ground Zero 11 years ago. We're bringing you a speaker the morning of September 11th who was in Tower 1 rescuing others when it collapsed. That's right, he was trapped in the rubble for 4 hours. His story as the highest-ranking firefighter to survive 9/11 is sure to be emotional, but I can't wait to hear his story and listen to how you can conquer anything and stay calm under the most extreme pressure. And I hope to have you here to hear him as well. So talk to our team, look at the site, but most importantly, plan to join us for this free event here in September. But my final thoughts are this. I only scratched the surface of the changes coming towards us. We have so many more PPACA regulations still being written as they continue to decipher what was in this bill. I encourage you to work with your local representatives to influence the changes that are most likely to come over the next few years. This bill was mostly crafted without the insight of someone like you, someone in the trenches. Don't let the modifications to this bill happen in the same vacuum. Most of your legislators will listen to you if you take the time to reach out. Even offer yourself as a local resource on a regular basis to them. Meanwhile, embrace where things are today. Plan for where they're going. Be more consultative. Educate yourself and never stop learning. Partner with someone who can mentor you. Of course, we would like to be the organization that helps you as you go through all of this. Remember, we're in this boat with you. Our success in the future is absolutely tied to your success in the future. That's why we put together these webinars. That's why we employ the best of the best with the employee benefit specialists in that division. And that's why we're bringing the summit to you again this year. Maximize all those available resources and let us know how we can help. Remember, if you're interested, we have the MLR FAQ from the IRS. We have the FAQs coming out of the Department of Labor on the summary benefit description, all of those things. We're here for you. So call us now. Let us know how we can help. And I'm going to go take a look and see if we had any questions up here. And it looks like we do. Let me see if I can get to a couple of those. I've got about 2 minutes, and I have got a lot of questions. So I see a couple of things. One, I see a question as to whether or not we will have a copy of this presentation available. If you would like a copy of this presentation, you absolutely can get a copy of that presentation by calling now at the 800 number on the screen and asking to speak with your employee benefit specialist. If you don't have one, our receptionist will gladly find one for you. Let's see. Are agent commissions included in the MLR? Yes, they are. Now, there is currently legislation looking to remove them. I hope that happens. If it does happen, that will absolutely help the fully insured book as well as the agent serving that market. So talk to your employee benefit specialist if you need to know more about that, but we are actively trying to get agent commissions taken out of that calculation, which would be huge for our industry. Okay, so yes, I did hear from somebody else on here that they are looking to move this back 1 year, and I am hearing that as well. If someone has unearned income, would that qualify for the 1% penalty? Tom, I'm not sure I'm understanding your question on that. I guess I would say to you that if you're asking me whether or not that counts towards their maximum penalty for the individual mandate, it's their taxable income that is used for that calculation. So if their unearned income is taxable, the answer would be yes. If the unearned income is not taxable, it would not be used in the calculation. In 2014, can carriers rate up an individual's premium on an individual policy for health conditions? The answer to that is no. There will be no medical rating for medical conditions. They will not be able to exclude that person. They will have to take them and immediately cover their pre-existing conditions going forward. The 60-day required notice for SBCs, I will try to answer that question offline because it is a little bit more complicated than I can answer in the couple of minutes that I have. How can we keep the tax credits outside the exchanges? You've got to get your legislators to make that change because right now that is not the way it works. And I believe that is one of the biggest things you could do to help make this thing better if it survives as is. Will the employer have the employee's W-2 or tax return information from the exchange to determine if they are eligible for the subsidies If they elect to insure the entire family on the plan, if they do, then that would concern me. Well, they obviously have their W-2 if they issued it, but there's a lot of talk about the privacy of the individual, and actually right now I expect another Supreme Court challenge talking about the constitutionality of an employer being privy to an employee's private information. So that is a whole debate that is about to be a firestorm. Is the subsidy based on gross income or adjustable gross income? It is on their adjusted gross income, I believe. I'll double check that for you. I was told the PPACA subsidies will only be on the silver plan. That's not entirely true. The PPACA subsidy will be based on the premium for the silver plan. So the subsidy will be based on the premium for that plan, but they can then use that premium for other plans, is the way that I have understood it. If I move to Costa Rica, will I be subject to these laws? I don't know, but our annual event for our top producers will be in Costa Rica next year, so we could ask those questions. Do I have a document that shows the breakdown of the subsidies for each income? Yes, I've got a couple of things I could give you, and again, I'll do some of that offline. Listen, we're coming right up on the hour, and I still have about 50 questions on here, so I'll tell you what I'm going to do. I am going to stop there, and I am going to answer the rest of these questions offline in a Word document, and please let me know if you have any additional. You're going to get an email from me in about an hour asking for feedback. You can also ask me additional questions if you just reply to that email. But again, I have a team of employee benefit specialists here at Insurance Network that are waiting to take your calls and talk to you if you need any help on any of this. So please reach out to them or to me or to Mike Dibben, our manager of that division. One thing I want to leave you with is we are here to help. So thank you for your time. I know an hour is valuable to you. I hope you found the time well spent, and thank you for your business.